they don't think this will be from a fall. Okay, so it's not from a fall, and this is multiple impacts that cause the injuries, to the internal injuries. Okay. Just like, getting hit with stomach real hard. Well, here's the other part of it, is that I understand this is the Georgia Bureau of Investigation that does these autopsies. Okay. They're saying that whatever caused these injuries happened within 24 hours of his death.
Nothing.
Well, there's some things that could have happened. There's things that had to happen. Something had to happen. You don't get this without something happening. So,
the child isn't even.
how does Mr. Benton, does he ever tell you?
No. Why?
About yourself? How do you know?
No. I don't even hit my child. That's literally part of everyone's issue is that I'm disciplined. His fault. I'm too nice. He's 2. So there's no reason to discipline a 2-year-old.
What you're implying?
Ma'am?
I said what you're implying just is so bizarre, just because of who he is and who he has always been and who he
always been?
Yes, like he would never, never. My child literally loves him. My child calls him dad. And he doesn't even do that. There's just no way. And if Karter didn't like somebody, or if Karter felt a certain way about somebody, he would definitely not be around them, and I wouldn't know, and I wouldn't even allow it. I don't let anybody watch him except for the babysitter and me and Dad. That's just what it is. And that's just because of his breathing issues. I don't trust people with him in that situation. So if I would never leave my child with him if I ever thought that he was even capable. The man is not even capable of hurting a fly.
I know Kiyon as a person. I know who he is, and I know how he is with kids, and especially with my child. He's in the process of trying to get past his own.
I understand that, but
So
sometimes good people make mistakes and do bad things.
sure.
I mean, it does happen.
Sure.
And I will tell you, it's from my experience, that when you have a child that's going through potty training issues, or kind of in that transition where sometimes they have an accident or they do that. I think there was some discussion about he peed on himself some, and a few times during this issue, in this investigation, that sometimes those people get frustrated, and that can make them act out angrily toward a child during potty training. I'm not saying you did.
No,
I'm just saying that somebody else could.
I understand what you're saying, and if that's the case, then do whatever you need to do. I don't care. Because at the end of the day, I know for a fact that in my care, nothing happened to my child. I know for a fact that when I got home, my child was not acting as if anything had happened to him.
It was almost 6 years ago, and do you still remember what happened during those days before?
Vaguely.
As you have explained once again, what happened then to Sergeant Collins and Lieutenant Meadows, do you stand by what you said?
Absolutely.
And also Marcus Jackson from DFAX was there, is that correct?
That's correct.
During the period of time after Karter passed away, did you try to stay in touch with the sheriff's department or law enforcement of some sort as to what was going on with the investigation?
Oh, yes. Yes, absolutely.
I mean, what would do?
I was consistently calling them for the 3 years.
And who would you talk to, do you know?
They would never come to the phone. I was always referred to the assistant to leave my number, and that they would get back to me, and they would never get back to me, which is why I continued to call.
Would that just be law enforcement, or did you also try to contact the district attorney's office?
But I would contact Warren's police department, the sheriff's department, and the district attorney's office.
And you heard the testimony of Ms. Davis, you're under oath. Once again, did you ever do anything to harm your child?
No,
Did you ever do anything to where you were reluctant or unwilling or unable to seek medical care for this child?
no,
Judge, that's all I have. Thank you, Ms. Davis.
Well, isn't a 2-inch laceration to a 2-year-old's liver serious?
yes,
It's very serious. That's why he died, right?
correct.
But he didn't say, point, he wasn't crying, it wasn't really alarming to you, was it?
He was not crying, he was not crouching over, he was not holding his stomach, he was not doing anything except for saying, "Mommy, stomach hurt," and vomiting juice.
And you expect the jury to believe that a 2-year-old crybaby, who you said cried over everything, who had a 2-inch laceration of his liver, wasn't really crying?
I expect him to believe what I saw and what I presented.
And you repeatedly denied that he would have done anything to your child.
That is correct.
But you deny that you did anything to your child.
Absolutely.
And the time frame, as we've all heard, is that you and Kiyon were the only people who had access to him.
During Sunday to Monday.
Right.
Correct.
Right. Other than the Saturday that you were at your father's house, right?
Right.
Okay, but he was fine that day.
He was running around.
And then Sunday is when he's not feeling well?
Sunday night is when he first mentioned, "Mommy, my stomach hurts."
Okay. And then into Monday?
Monday, after I got home from work, yes.
Okay. But you say Kiyon would never do anything like that.
That is correct.
But you deny having done this thing.
That is correct.
So who would have done it if the only two people were he and you?
That is a good question.
So we just don't know.
We don't. Considering, and I will say this, nurses, they've all testified that my child did not have bruises on his body when he was presented to them. That is Tuesday morning. So, according to that time frame that you're trying to give me, by Tuesday morning, if something like this would have happened, he would have absolutely shown bruises or something on his body to a complete staff of medical professionals. And every one of them got on this stand and testified that they saw nothing.
Okay, so why doesn't Kadeem get to FaceTime his child?
Me and Kadeem were going through obviously a court battle, and he was annoying me, so I blocked his number. He could still contact me via either email or he could call me.
He was annoying you by trying to figure out his overpayment of child support. So, but you heard Kadeem's testimony about how you would block him when you got mad, but that he would always get to see his child, FaceTime or talk to him.
You also heard him say that he can only get his child during the time in which he's off work, so that would mean that he would have to be off work from his part-time job and his job at the fire station, which is not something that he can just say, "I'm off." It's based on his schedule.
I'm not talking about his work schedule, whether or not he gets to keep Kadeem. I'm talking about the fact that his testimony was that even when you would block him, when you'd be mad at him, he would still see his child on FaceTime or be able to call the child. And now, the weekend where your child's suffering a lacerated liver, all of a sudden he can't see his child.
No, I called him on Monday and asked him if he could watch the child.
Right. You called him Monday at what time?
When I got off of work, when he threw up in my arms.
Okay, after he's been sick for a while?
I saw him throw up for the first time that moment.
So when Kadeem doesn't take Karter, You don't make a doctor's appointment for him.
It's at this point around 7 o'clock, and after hours is what you would have to do in order to get an appointment. You would have to call the number, and if you get an appointment, they will then tell you that you can come in at a certain time the next day. So there's no instance where he would have been able to see any medical professional unless I called 911 that day.
Urgent care's open?
I don't know about urgent care.
Emergency room's open?
He did not present any symptoms where I felt like I needed to take him to.
And that's not what I asked you. I asked you, was an emergency room open?
I'm assuming
You're assuming
emergency rooms are open.
they're not open 24 hours?
I'm assuming they're open 24 hours.
You assume that's not something that you just know, you're just guessing that that's true?
I don't work for an emergency room, so I don't know what to
And neither do I, but I don't need to work for an emergency room to know that I can go there at any time.
Correct.
Right. So you do know that.
You can go to an emergency room at any time. That's basic information.
And if you had called your doctor, chances are you would have gotten a recording that said this is after hours. If this is an emergency, please hang up and dial 911.
Correct.
You did none of that.
Why would I need to call 911 for vomit or juice?
Or go to the emergency room.
He was vomiting juice, and this was not the first time that my child had vomited.
This case is about a mother who refers to her child not by his name, but calls him the child. That child's name is Karter Ambrose, and his mother killed him. Repeatedly called him the child. He didn't have a name, he didn't have an identity, which he testified. He was just the child, like an unnecessary piece of chattel or an object that gets thrown in the kitchen junk drawer. I told you from the start, you don't have to choose who did what. They are each party to the crime of each other. They are parties to each other's crimes. And there is no doubt when 2-year-old Karter was murdered. He was murdered by the two people who were supposed to care for him. Now, I get 2 opportunities to talk to you. So I get this opportunity, and then the defense is going to get to talk to you, and then I get to come back. At this point, I kind of want to walk you through the indictment, because there's a lot going on, so I want to take it charge by charge. So count 1 is malice murder, right? Now, the defense pointed out something, I think when talking about malice murder that involved premeditation. Premeditation is not an element of malice murder. Malice can be formed in an instant, a depraved heart.
And they're saying that either she did it maliciously, with malice aforethought, or, and they've also got Kiyon Benton charged with the same thing. He's not here. He's not here. Of course, they're being tried separate, but if he was there when this happened, then why is he not here to testify against Ms. Davis? Because it didn't happen. Malice murder. Most serious of any murder that there could be in our state. That she had gone to work up in Jones County or in Milledgeville on that particular ill-fated Tuesday. And that she had been trying to get in touch with Mr. Benton. Finally got in touch with him and they FaceTimed each other. I mean, you've heard all that. There's no sense in me going back over it. And so Mr. Benton put the child in the car and drove 2 or 3 minutes to the pediatric place for an emergency like this. And that basically the whole time Miss Davis was on the phone with Mr. Benton, and she even heard some of the conversation when she got into the pediatric place. I don't know if it was are almost another 3 years later when we get here. Okay? And the state would have you believe, don't worry about it, nothing to it. Folks, there is something to it. That's for you to decide if that's something that you'll tolerate as citizens of this county. Once again, the burden of proof is always on the government to prove the charges beyond a reasonable doubt. Okay? And I don't mean to bore you with what I'm saying. Okay? You know, there's the way that I was raised, if there are flies on something, then there's a problem. Okay? And there's flies all over the phone.
Doesn't bother bringing anything like that up. But justice has no expiration date. Karter's life had the expiration date. But this trial does not. You want a smoke screen? There it is. That's their smoke screen. Be mad at the state. Don't be mad at the two people who had custody of this child when he suffered a 2-inch laceration to his liver.
They've still got the light on, Bob, so. You won't know when they need us if they don't turn it on. Okay, the note says, we have one juror who says she isn't open to discussion, who is combative to the room. What do we do here? She said she will not change her mind in a million years. Please advise. So, the issue for the court is a juror should never surrender an honest opinion. But a juror does have to participate in deliberations. So my suggestion at this point is that we Allen charge them, because that talks about you have to listen to each other. Let me pull that and look at the pattern. Because we have to be very careful with investigating which it is. That a juror has a belief based on the evidence that they're unwilling to surrender, which the system is set up for, or whether a juror is just refusing to deliberate.
Judge, I would argue to the court, I don't think we've got far enough yet. I think it's probably too early to do an Allen charge.
Okay, go ahead.
I would suggest that we come back Friday morning and give them some more time to deliberate, and then after a period of time that the court deems appropriate, if the stance is still that way, then do the Allen charge.
Well, I think it's not so much the first paragraph of the Allen charge, but the second part that says each juror should listen to the arguments of the other jurors with a disposition to be convinced by them. If the members of the jury differ in their view of the evidence, that difference of opinion should cause them all to scrutinize the evidence more closely, re-examine the grounds of their opinion. Your duty is to decide the issues that have been submitted to you. If you can, conscientiously do so. In conferring, you should lay aside pride of opinion, bear in mind, a jury room is no place for taking up and maintaining in the spirit of controversy either side of a cause. You should bear in mind at all times that as jurors, you should not be advocates for either side. You should keep in mind the truth as it appears from the evidence, examined in light of the instruction of the court. I would encourage you to continue this case. I mean, because just sending them home is not going to change the dynamic. I don't know that the dynamic should change. I don't know what, because combative is one thing, never surrendering an opinion in a million years is a different one from a legal standpoint. And the court has to be very careful in invading the province of the jury. However, I'm talking myself around into what I think is the appropriate thing. It is late. Everybody's tired. I think I'm going to send them home. Tell them to come. Thank you, ladies and gentlemen.
I think it's all the same.
For the record, I believe that is Shane Howard, who has handed me another. She maintains she's being harassed by the foreperson about her vote. So I'm assuming, so we're going to send everybody home, let everybody cool off, and then